Boom. Hey, folks. How's everyone doing? I'm dragging myself along, and I don't know. It doesn't seem like there's a whole lot of you here today, so I'm not sure what's going on. Maybe I'm doing something wrong, but let's. I guess we'll sort of talk about status at this point, which is I still have the flu, and I am suffering. I got the fever, I got the chills, I got the aches, I got the pains. Bederow's on Young Jerks. That'll do it. That'll do it. So yeah, I am suffering along today, but I didn't want to cancel the stream because I kind of wanted to hang out with you guys. And yeah, somebody says you look good for being sick. If you say so. Somebody says, why aren't you in bed then? Because I wanted to hang out and do a stream. And yeah, it's been a bit. So I also saw some people asking for a Potter update. So Potter has had his Potter's had his biopsy. We don't yet have the results back. They said that it'd be 5 to 7 days. So it's basically any time now that we will get the results and find out what's going on with Potter's foot. So the leading options are either either that he's got an infection, or that he's got some sort of toe cancer. So we're hoping it's not the cancer thing, because the cancer thing would distinctly suck. But I mean, of all the places for the dog to have cancer, the toe is, I guess, the best of the possibilities. So yeah. All right. We got a bunch of stuff to cover today. We're going to cover it as long as I can, and we'll just have to see how long that is. Because I'm not feeling well, we are not doing like, have a beer goals. I've got some water, but I should set a goal, and this is my goal, the first one. So I have also made the decision that I want to try to cut back on the amount of Coca-Cola I drink. So, because I go through a ton of this stuff, and I haven't had any today. So I just set a goal, and this is the first and likely only Coke I will drink today, assuming that you guys hit the goal. So yeah, I am feeling the caffeine withdrawal, but yeah. All right. Well, no Coke. I don't like Pepsi, so we're not doing Pepsi. I've also been drinking a whole bunch of water. So, all right. Let's dive in with the Karen Reed civil case. Now, I actually genuinely expected the Karen Reed civil case today to be super, super boring. And what I mean by that is that it's a status conference in a civil case. So normally these things are really, really uninteresting. They're boring. There's nothing that really goes on. Typically what happens at a status conference is that everybody comes in, and there's going to be some complaints about, like, well, we're waiting on discovery, and the judge will be like, so can we get a timeline for discovery? And they'll say, okay, we think we can have this in for like 2 weeks. And the judge will say, okay, cool, we'll set like a 2-week, a return, and if you guys could file like a letter in 2 weeks to, if you could file like a letter in 2 weeks just to let me know where you sit. And that's kind of what usually happens at status hearings, right? They're usually pretty boring. Which is why I was surprised that this one actually had some stuff go down. There were some surprises that happened in this one. And yeah, this is the okay, y'all are still suing then. Good chat. Yes, this is a lot of what happens in status conferences is, all right, are you guys still planning to sue? Yeah. Are you guys still planning to defend? Yeah. Okay. What do you need to do for the next steps? Cool. Do the next steps. And then that's it, right? Because how do I put this? Most court is boring. Most court stuff. I appeared in court today. I had a court appearance. My court appearance was a slightly more interesting appearance than your average appearance, but it was literally, hey, Your Honor, I'm here on the beep file. I didn't say, hey, it was, good morning, Justice. I'm here on the matter of beep. And my friend and I have a joint adjournment request. We're both seeking to adjourn this matter. Here's some details as to why. And the judge is like, the justice goes, okay, that makes sense. Adjournment granted, over it goes. And that's kind of the average thing, right? That is most of what happens. When you get to trials, the most common trials are super uninteresting, right? They're just super minimal. So what you get is, most trials aren't the Karen Reed trial. They're not the, they don't involve secret hubby poisonings. They don't involve, all of these things. Yes, I was on video conference, so nobody caught it. So the average trial is something like, Bob stands accused or Jim stands accused of, stealing a bottle of liquor from the liquor store. All right, we're going to call our first witness, and the first witness is the liquor store owner. And the liquor store owner is like, hey, hi, I'm the liquor store owner. Prosecutor's like, so tell us who you are and what you're doing here. Well, my name is so-and-so. I own a liquor store. And the prosecutor will be like, okay, so did anything interesting happen on this particular day? Yeah, this guy came in. He looked sketchy. He picked up a bottle of vodka. I said, hey, you need to pay for that. He gave me the double bird and then walked out the door. And I said, stop, don't steal my vodka. And he yelled, stealing your vodka, and then ran out the door. And I called the police. Okay, do you see this person in court today? Yeah, he's right over there. Can you describe him? Yeah, he's the guy with the hair and the nose. And defense counsel stands up and says, identifying my client. Okay. Cross-examination. Are you really sure it's this guy? Well, pretty sure. Have you ever been mistaken about a person? Yeah, it happens. It happens. So, could you be mistaken about this guy? I don't think I am. Okay, cool. Then they're done with this witness. And Elf Wiggins is correct. They would also say, what town did this happen in? The prosecutor would ask what town it happened in. And they'd be like, oh, this happened in Edmonton, Alberta. Okay, cool. Done. So next up, they call a police officer. And the police officer says, okay, hi, my name is Officer, Bob Bobson. And, reg number 1234. Okay, were you on duty on this day? Yes, I was. All right. Did you get called out for a call? Yes, I did. Can you describe that call? Well, I got a call about a theft from liquor store. Okay. And what was the description? Yeah, they said that it was a man with hair and a nose. Okay. And so what did you do? Well, I spoke to the liquor store owner. Okay. And then what? And then I left and I went and looked around, and right in the alley behind the liquor store, I found a guy with hair and a nose, and he was drinking the bottle of vodka. All right. Did he do anything when you saw him with the vodka? Yeah, he flipped me the double bird. Okay. So then what? So then I arrested him and I put him in custody. And did he say anything? Yes, he said, I stole the vodka because I really like vodka. And the defense counsel's like, objection, admission. And the Crown and the prosecutor's like, really? And that's kind of the usual trial, right? Defense counsel's like, are you sure it's the same guy? You'll agree that all sorts of people drink vodka in alleyways. You'll agree that like hair and a nose are not, super distinctive. That's the usual trial. The usual trial is fairly straightforward. It has no fireworks. It has no exciting moments. It has no, you don't get the like showdown like in Rust where the prosecutor gets up on the stand. You don't get the Karen Reed thing where, you're just sitting there watching it the whole time going, how is this still a trial? It's just not sort of done. Status conferences should be even more boring, but for some reason, this one isn't. So let's have a look at this one because, there were things that happened, and I was like, how come things are happening? Why are things transpiring? You might be saying, as a lawyer, why do you watch court stuff? And it's like, well, because I get to watch the cool court that I never get to do, right? You could go an entire career and never have a Karen Reed trial. You could probably go like 3 or 4 entire careers and never have a Karen Reed trial. It just, it just doesn't happen. So we get excited when we get to watch it. So here we go. Wait, is that a different tie? No, it's the same tie. All right, here we go. Tell me you guys can hear this. Tell me you guys can hear this because I spent my entire day, not really, but I spent like my entire lunch hour trying to get this audio fixed because when I started the day, I was trying and it was not piping through. So, all right. Excellent. People can hear it. And of course, they're going to zoom in on camera.
Good afternoon, folks. Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe and Alia versus C&C Hospitality, LLC, DBA, CF McCarthy. That Alia case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with plaintiff's counsel. And if you could state the party you represent as well, thank you.
So we're also going to talk about just how weird this little bit is. Because this little bit is insane. Most lawsuits are like one lawyer stands up for each side, and then that's it. And then that's it, right? You just have one lawyer on each side. This one, we're going to hear like an entire clown car full of lawyers. It's something.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
One for the plaintiffs.
Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
2 for the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Good afternoon.
Good afternoon, Your Honor. Charles Waters for defending Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Keppel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett.
So that's 7 just on that side, and they're not done.
I'm sorry, did you say the waterfall?
Waterfall, yes, sir.
Got it.
That's in the agenda. They also have a waterfall on
Good afternoon.
there. Good afternoon, Your Honor. Looking those on behalf of the defendant, C.F. McCarthy's.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone.
Holy crap, that's a lot of lawyers here, right? And this judge is just like, okay, I guess this is going to be a thing. This judge got assigned this because basically, have you ever had the thing where it sucks to be good at your job? Because suddenly you get assigned the like all the work and the biggest, scariest work. Well, this judge has this problem because I'm guessing this judge got assigned this particular task because he's probably really good at his job and probably has a really good demeanor for it. And so they've basically been like, all right, we need the person who can wrangle all this shit. And that's you. And he's like, fuck. So, yeah.
To the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all were going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going.
So the first thing I noticed here that I really liked, some judges will come in on a situation like this and they'll come out swinging. Like they'll just be like, all right, you will respect my authority and I am going to yell at you and I'm going to be a drill sergeant and I'm going to get everything in line. And that never makes things better, right? Those kinds of judges are, how do I put this? Those kind of judges suck and they need to not do their thing. So this guy instead is like, all right, we've got stuff to do. Let's just, let's take care of some business, but let's do it in a respectful fashion where we all respect each other and we all, we all have some compassion for each other. And I'm like, thank God, because the last thing I wanted for this one is Judge Shouty. And yeah. All right, here we go.
Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea. Procedurally, where do you stand?
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are is significantly deficient at this point. We're still waiting for the records to come in. So
this guy's already going to be hard to listen to. I feel like this is the kind of guy who could bore a brie into becoming a Parmesan. So
we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor.
Right.
So when the stay was lifted, all discovery was served on the parties or thereabouts. give or
When you
take.
say discovery, we're talking about depositions,
Requested.
documents, notices of depositions or no?
Only one deposition has been noticed and it's been tabled because we don't have any documents at this stage.
I see. Okay, so it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants, that's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay.
All right. So basically, they wanted a whole bunch of the stuff from. They wanted a whole bunch of stuff from the DA's office. The DA wasn't giving them, and the reason why they weren't giving them is because, well, there was an ongoing criminal case. But now that the criminal case is done, they expect that they'll get stuff soon. Maybe sometime around when this guy is capable of finishing an entire sentence.
All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's...
All right, I just want to stop here. And my first thought about this guy is they need to write a Bond movie to have this guy be the villain in, because he's got the baldness thing going, and that seems to be a common feature of the Bond villains. But B, that accent is that is some top-notch villain accent right there, and they should absolutely just like make the entire movie around this guy. And you'd pay money to see this guy say something like, no, Mr. Bond, I expect you to die, right? You'd pay your bones for that. So yeah.
Perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that are at issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point.
So this is the bomb that they decide to drop, right? This is the place where they're like, all right, we're gonna take this whole civil proceeding and we're gonna make it exciting. Like, we're gonna have a disco ball, we're gonna have lasers, we're gonna have smoke, we're gonna have like pyrotechnics, because he's like, Karen Reed is intending to bring affirmative claims, and here we go.
Including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims affirmative.
So if you missed it, they're planning to sue for, amongst other things,
conspiracy.
Yeah, they're like, all right, you thought this is your civil lawsuit? This is our civil lawsuit. We're taking over. We are taking this civil lawsuit and we are driving it off a cliff and like directly into the face of Michael Proctor. It's like, this is our civil lawsuit right now. Here we go. Welcome to the party. And So Ellen Jackson had sort of hinted of like, wait for it, we got some big shit coming. This is the big shit. This is this is the huge deal. Meanwhile, Michael Proctor is at home on unemployment, and he's sitting there like eating like a thing of Ruffle chips and homemade potato or homemade onion dip, and he's sitting there watching this, and he sees his name get mentioned, and it's just like it's this if you thought Proctor couldn't have any bad days left, he's still having some bad days. So yeah.
Claims against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reid's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage and the sally port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts.
So this is the thing. I saw somebody saying, won't they just sever those claims? Here's the way they get around the severance is they're saying, listen, this is all the same facts. We're all talking about how did John O'Keefe die? And what they're looking to do here is to bring an entirely different theory of the case. And that is not Karen Reid ran over him and drove off and, into the night, but instead that John O'Keefe was killed inside the house, was dragged outside of the house, was left on the snow, and that all of these people knew about it and conspired to, to frame Karen Reid. So they're going to bring a lawsuit for these people all framed Karen Reid, which includes the police, which includes everyone in the house, which is interesting because they didn't say Colin Albert. Interesting, right? I think they've got a pretty decent argument for it, but this is going to be hotly contested because when I say hotly contested, certainly the other side is not going to want to allow this. They're not going to want that to happen. They're going to say, no. You need to put that into an entirely separate lawsuit. And Colin's broke. Here's the thing. Sometimes you still sue brokies. And the reason why you do that is because sometimes story I got told from another lawyer was they had a claim and the claim was for like $8 million and it was against 4 people. And one of the people was basically completely indigent, right? They lived in a trailer that they didn't own, on land they didn't own. They had no earnings, no anything. And that person was like, please cut me out of the lawsuit. I have no money and no prospects of getting money. I am like, not only am I not dirt poor, I'm like, my dirt is getting repossessed levels of poor, right? And the civil lawyers were like, no, you stay in. So they got a claim against all 4 people, and they got about half of their money out from going after the people with money. And they thought, well, okay. But then one of the lawyers was sitting there reading the paper, like in the era of the physical newspaper. He's sitting there, gets up in the morning, flops open the paper like it's some 1950s, sitcom. And right in the thing is a story about local man wins huge lottery. And guess who the local man is? Well, it's the brokey. It's the guy who had no money. And they were like, Can we still enforce on him? Yeah, we're within our time limits. We're within our and so they went and they immediately they served on the lottery company that they had a first in time claim on this. And so the lottery company, instead of paying out the big win to this guy, paid most of it out to the people he owed money to, and got to keep like the little bit of leftover stuff. That was it. So I don't know what the strategy is here, but yeah.
For us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in.
And the court is sitting there like, okay, we've already got a clown car proceeding here. You want 10 additional parties and you want 10 additional lawyers in here. Ooh, what a circus. What a clown show this will be if that happens. And let me put it this way. I am so glad to be watching this proceeding and not arguing this proceeding, because if I was arguing this proceeding, I would be sitting there going, oh my God, how do we even get started? Whew.
To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading, serve all of those new parties with that complaint, allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what
the court is like, yes, this is gonna get briefed. Are you kidding me? This is gonna get briefed, because of course this is gonna get briefed. What do you might be saying, briefed? Are they gonna put underpants on it? Well, not exactly, but the issue is basically the court's going to make them do written submissions, right? Written argument, because the other side is going to have to get to respond. And certainly the judge is like, I'm not responding to this right now. Are you kidding me? This is like, you came in and you brought in a time bomb, and not like, just a simple time bomb, like the Batman style lit fuse thing that you just cut the fuse. This thing is like some complicated mess of wires. And you're like, hey, I need you to diffuse this. And he's like, this is not a one day, this is not a 1 day project. So this is not a happening today kind of thing. Fair enough.
the plaintiffs are going to say to this rather extraordinary process, but go ahead.
But that would be, otherwise it's
this rather extraordinary process is a fair description. I saw some people on Twitter being like, hey, this is him throwing shade. I don't know that it's really the judge throwing shade or just the judge going, yeah, this is going to be a bit of a complicated thing. So, yeah.
It's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate.
So why does the court want to have the same facts heard together? Because you've heard this lawyer repeatedly kind of banging on that drum, right? They're not separate. They're the same facts. Well, because the court is leery of having two separate, proceedings deciding on the same facts that could theoretically make opposite determinations on the same facts, which, picture they run these as separate trials, right? And trial number 1 says Karen Reed did it. She owes all the money. Okay, that'd be trial number 1. But then trial number 2 says Karen Reed was framed and the police owe all the money. These two rulings would be completely contradictory, right? And the court is going to be like, nah, that's not really a thing we want to enable to happen. So, yeah. All right, let's keep going.
And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right, let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff to order extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed to extension?
Agreed.
Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet.
By the way, if you're watching this on headphones, you probably hate your life because for some reason, the audio jumps from the left mic to the right mic to the left to the right and I'm like, just one audio input or two audio inputs, or just like don't have it jumping around because, oh my God, I've got this on headphones and it sucks. It sucks. If the O'Keefes despondently dropped their suit midway through, would Karen have to drop her countersuit? No. No. And there are several cases where a suit is launched, a counterclaim is launched, the original suit is launched, or the original suit is dropped, and the counterclaim continues on and may in fact prevail. So
until a lot of the document requests have been answered in the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
All right, thank you. Let's hear from CF McCarthy, then.
Your Honor, with a similar vote as to Waterfall, we are putting the finishing touches on our discovery responses. The last leg of it is just collecting communications from employees that are the incident, some of whom no longer work with CF McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear the.
I can't imagine that like CF McCarthy and so forth, like the Waterfall would have too much objection to the big fight. because ultimately, if it does turn out to be like, if the court or if the jury agrees that it's a homicide, it's that clears the bars too, right? So yeah.
Plaintiffs then, in terms of the response to the procedural issue that was raised in particular by Ms. Reed's counsel.
Oh, they're not going to be happy. So yeah.
Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your
It's the
Honor.
first notice you've gotten?
Of course, I would
Not how the
expect
court
that.
system likes this stuff to work, folks.
I would expect the courtesy of a meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1980.
He's like, I got sandbagged. And the thing is, this is a, you know, this is the time when you bring up new stuff, right? This is, you know, I don't see anything super upsetting about the fact that that they were like, yeah, we've got some new stuff we want to bring up, because that's what a status hearing is for sometimes, is to bring up stuff. But he's like, why didn't they do a meet and confer? Why didn't we have this conversation? And the judge is like, yeah, okay, but what of it? So, yeah.
83 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal. So Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact,
so the plaintiffs were like, hey, we don't want this to go to federal court. And the defense is you know, Karen Reed's team is going, yeah, we don't have to bring it in federal court. We can bring it right here. It's doable. Now, I wish that this camera was located somewhere slightly different, because, I mean, sure, this guy's ear looks just fine, I guess, if you like ears. Actually, I don't know. Some ear person is going to be like, no, this is a terrible ear, or whatever else. But, like, it'd be good to see his face as opposed to just this ear camera that we've got here.
this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against.
I don't hate ears, but like, there's a difference between somebody who's like not a feet guy, who probably is like not opposed to the concept of feet, versus people who are like feet people who are who get up to some weird stuff sometimes. So yeah.
It's this is not just a wrongful death action. Our narrative of what took
But
place.
it is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice, as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with third-party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach. And we'd like to brief that for Your Honor, but we're raising it at the status conference so that because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it. And then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor. All right, so
He's like, all we're doing is we're saying we want to bring this thing. We want to start this off, but we're just, we got to do proper filings. We got to do all the things. So I don't think this is unreasonable, right? So, yep.
I don't know that there's any ruling by the court today that would have to be made relative to that because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case.
Hi, Judge. That's us. Yeah.
But at its heart, there are at this time 8 parties involved in this case, correct?
yes, sir.
There's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today. So we have a deliberating jury right now, so I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it,
He's like, I might have to go deliver a verdict. Somebody might be going to jail in the middle of this. So, y'all just be aware that I might have to go do that. So, it's the thing. It's kind of funny.
To get you a trial date as soon as practically this spring on this case, but to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way you wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative.
Well, you're saying an affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defense.
No, they didn't say affirmative defense. I thought they said an affirmative claim. I.e., this is not a defense. This is, we are suing these people for put the money in the hand. Also, I did this judge dirty on this pause. Okay, moving on.
Offenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So,
Judge, we're saying somebody else did the murdering. I feel like he should kind of get to the point here. He's like, Judge, our client didn't do any murdering because those other people did. And then they covered it up. And, that's our issue here. We're saying our client didn't do the murdering because those people did.
So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down two separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without the prejudice.
Paul O'Keefe here needs to stop with the face. Like, his face is at a 7. They needed it like a 3. So, yeah.
The plaintiff. Discovery is already ongoing. But you have 2 depositions, for example, of parties in 2 separate cases where we can have one and the claims could proceed at the same time. Just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide ranging as they've just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I'm certainly not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate.
The court is like, yeah, okay, so at the end of the day, this is not actually before the court yet. So I'm not going to make a decision because you just told me a thing you plan to do, but you haven't actually done it yet. So we're going to wait until you do it. Cool.
None of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case. What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. As we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are,
I'd say, probably a couple of weeks.
Emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident.
Look, if you're not a lawyer and you're in this room, you're probably either suing somebody or being sued by somebody. Everybody's getting sued. It's like an Oprah show. You get a lawsuit and you get a lawsuit and you get 3 lawsuits. Yeah.
It is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is the cases, Your Honor, limit when a claimant can claim emotional distress. The case is talking.
You bring in a third-party notice, so to let somebody know that you think that they are on the hook. They can contest it, and if it goes through, then they're now on the suit. And, yeah.
About temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, That claim is for negligence/reckless/intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow...
Okay, I'm a little bit of a child about that last name, but carrying on.
...how started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is played in the complaint, that would satisfy the limitations that the case law sets out.
All right, so let's talk about this. When somebody dies, just because you have a SAD, it doesn't allow for a lawsuit. There's sort of two areas where you're going to get the lawsuit, and the one is the issue of if you've got a like an actual harm, right? So if you've got somebody who, like a spouse who was expecting to get money from it, but with regards to the emotional distress aspects of it, there are limits on that. And the reason why there are limits is because let's imagine like we're watching this, and as we're watching it, one of the lawyers will say this guy in the back here with the gray hair, his head explodes, just boom. And we're all really kind of horrified by that, right? Because we don't really want to see somebody's head go pop. But that doesn't mean that we can necessarily sue over that. Or let's imagine that, like, I don't know, let's get mildly controversial and, Charlie Kirk dies. He's shot. Lots of people upset by that. You don't even have to like Charlie Kirk to not like seeing somebody get shot. That doesn't mean that you can sue over that, right? Because otherwise there'd be millions and millions of potential lawsuits over any sort of death, right? Any sort of fatality. And so there has to be more of a connection to it. There has to be more of a direct linkage, because otherwise, you don't want to have it where there's hundreds of complainants or millions of complainants or tens of millions of complainants, right? The number of times when there are deaths and so forth that are seen on TV now is tremendous, right? How many of us saw the video of like the Luigi Mangione killing? Doesn't mean we can sue. So, yeah.
Spatial and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother. Again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim.
Now, the thing is that there's a difference between There's a difference between like finding out about it versus coming across the body, right? I feel like that is a bit of a different thing, right? And just being like, well, the body was old by the time you got there. Like, I don't know that there's explicitly like a room temperature rule here to be like, all right, because the guy had been there for a while and had cooled off, that, that doesn't count. I don't necessarily like the argument here is what I'm mentioning.
Importantly, Your Honor, there is a remedy here. If for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants. If they want to be heard, you've filed separate motions, essentially arguing the same relief. But if you have anything you want to add, you certainly can. Waterfall?
Yes, Your Honor, we have the Waterfall, just very briefly. I think the distinction here the council's making is that these claims, these infliction of emotional distress claims are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of a son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Cake Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress.
Now you might be thinking, wait a minute, why are the bars talking, right? Why are the lawyers for the bars? Why do they say anything? Well, because they're also in this lawsuit. And I know it's going to be easy to forget this, but the bars, there is a potential viable claim against the bars. And, the argument is going to be that the bar's overserved. So, they're here arguing that, right?
Injuries. If you've reviewed that case, I'll give this case site, 385 Mass 323. It's a 1982 case. So it would seem to suggest that that emotional distress is really not preempted by the wrongful death statute.
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that that's a problem for the plaintiff moving forward, and that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss?
No, Your Honor.
No. Okay. All right, great.
They're like, everybody said what we want them to say. So, here's the thing about being a lawyer for like C.F. McCarthy's in the Waterfall right now, is that they get to just kind of glance over to the like team of like everybody, right? And be like, oh, right. The 62 lawyers over there will handle it. And I mean, I've had moments, as a junior lawyer where you're sitting there and you've got a co-accused and like I'm representing, this one person, and this other guy who's on the file is being represented by somebody with like 40 years of experience. And, sometimes it's like, well, I'm just going to let that person lead because why wouldn't I? Yep.
All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief?
This is important because even if, so long as a claim isn't completely dog shit, because there is some standard to the claim has to be plausible, as a fact. So if the allegation is that, Karen Reed is an alien who used psychic powers to kill John O'Keefe, then that claim would not be, accepted as true in a disputed thing. But otherwise, the court says, listen, because you want to dispose of this without a jury, that we have to take every disputed allegation as in favor of the plaintiff at this stage, because we're going to assume that they could prove the shit they're claiming. And if they can't prove it at the trial, then okay, that's on them. They've failed to prove it. But at this stage, when we're thinking about just throwing it out without a hearing, we have to decide if they're actually going to, if there's a claim that's made there. So
the answer is yes. This is a motion to dismiss. The lowest standard, the Brum case, plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today.
All right, so here we go. They are going to launch into this is sad violin time, right? This is sad violin.
Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew.
Oh, fuck off. First of all, if we're going to use the nickname that his kids used. If I'm the judge, I would have just been like, no, you will refer to him as John O'Keefe. Like, oh, come on. Like, that just feels manipulative.
Jay no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. And Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home.
So this is feeling familiar, and it didn't land the last time, but we'll have to see if they can make it land on a lesser standard.
There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents.
By the way, this lawyer's not talking to the judge at this point. This lawyer at this point is talking specifically to us. He's talking to the cameras. So he's showboating. And you can feel how you want to feel about that one. I am sick, so I can't yell to the extent that I would like to yell.
After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness at around 6 a.m. They rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead.
Can you imagine if you're one of those people who's got like a kind of shitty nickname? You know, it's like, I'm going to call him Stinky because that's what all his friends at the bar called him. Yeah.
That's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public.
Turtle Boy has entered the conversation. Now, I just feel like any time that you anytime you bring up Turtle Boy, I feel like things are getting worse for the case. But yeah, I'm not saying John O'Keefe had that nickname. I'm just saying a hypothetical person with some sort of crappy nickname, because people have it. Yeah.
Like information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So
wouldn't that be a claim against Turtle Boy? Like, you want to sue Turtle Boy here? Okay. Like, you could name him as a party if you think Turtle Boy did shit, but yeah.
The first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument.
Okay, cool.
JJ's parents are the next.
I hate it when lawyers say we reject that argument, because nobody gives a fuck about your opinion. Say that argument is wrong and here's why. But like, dude with the frosted tips here, are those frosted tips? I don't know. But like, nobody gives a shit what you reject or you accept. And nobody's expecting you to accept the other side's argument. That's not what lawyering is about. Like, just argue it, dude.
Of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out, first, the wrongful death statute, it has two components for damages. It has two buckets of damages. It has the estate's damages. Those all are JJ's damages, his conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The
KFC does not have a sale on those buckets.
lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings two separate causes of action. One for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote,
God, this guy starts making a point and the U.S. Postal Service delivers it faster than he does. Christ. Like, he's trying to be forceful, but I'm getting to, like, just get to the fucking point here, dude.
Argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute. And that's page 334 of the Cimino case, Your Honor. Cimino.
So why can they bring the same stuff in a civil suit? Well, because the standard of proof is different. Same way OJ was allowed to be sued after, after the OJ trial. So the criminal trial has a standard of proof beyond a reasonable doubt, but the civil trial has a standard of balance of probabilities, more likely than not. So they can, the criminal trial establishes that it was not proven beyond a reasonable doubt, but it doesn't establish that it was not, that it can't be proven to a balance of probabilities. Whereas the reverse is kind of the reverse is not true. If Karen Read had been convicted at the criminal trial and they had said, okay, we have proof beyond a reasonable doubt, then that conviction would be sufficient in most places to say, okay, yes, that establishes proof of civil liability as well. So, if that makes sense.
Still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident. Because as you pointed out, the Farrader case.
I love how they cut over here to Jackson going, this is some bullshit. This is the best facial expression right here. He's like, yeah, I have some thoughts about this, but I can't express them in court because I would get sanctioned if I said the things I want to say.
Stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis.
And the reason why he's going fact-intensive analysis is that he very much wants this to, if it's fact-intensive, then it's got to be solved by a jury. And he doesn't want this to get tossed out at this point. So, yeah. This is the kind of thing you argue is like, this has got to be all the facts.
And when we apply the law to the facts of this case, let's look at where, when and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship.
By the way, incredulous is the wrong word there. Incredulous is a quality of a person, not a quality of the statement itself. Like, lawyers, I know you like the big words and you want to be known as the person who knows the big words and uses the big words and, you know, all of this. But it's important when you're using the big, expensive words that you get them right. He's like, I can vocabulary too. I'm like a lessee. Look at me vocabularying. And I'm sitting there going, sir, you just vocabularied yourself right into a wall.
To what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no...
Thing is, he's not actually arguing bad. Like, he's got some good points. He's just arguing them badly and over much. Part of the problem here is that this is a motion to dismiss, and he's defending a motion, like he's defending against a motion to dismiss. And usually the judge is on board with the motion to dismiss fairly quickly, right? Usually you've got a judge who's like, or sorry, not with the motion to dismiss, but with the, usually they're on board with like not granting it fairly quickly. And there gets to be a point where the more you argue it, the more you're convincing the judge that it needs to be argued. And that is kind of a, it's kind of a risk.
A close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because
Don't lie to the court, dude. Don't lie to the court. I want to talk briefly about fuck off. No, you don't. No, you don't. Lawyers always promise, like, I want to talk briefly about this, and they never do. And yeah, just tell the court I want to address this next.
she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that, does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury, contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own two eyes, I will refer you also to the Cohen case, which they cite for different reasons, but in it, the language talks about sensory perceptions. To suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But
it's still just learning that a close family member has died. And you're like, but she heard it in a slightly different context. Like, okay. Yeah.
Have experienced the event or the injury and enters into your consciousness, that is the very reason.
We're just going to go back a little bit here because, yeah.
Use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED.
Oh, fuck off. Obviously, you can use other senses because otherwise no blind person could do it. Yeah. The thing is, there's a difference between, like, hearing the death versus, like, hearing about the death through the rumor mill or from something, somewhere else, right? Nobody's saying you have to taste the body, but they are saying that you can't just hear about it. Yeah.
Have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it.
Yes, I mean, if she literally tasted the body, then I would say yes. But this is heard about, not... Yeah. Ugh.
It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim.
If I'm the judge, I'm like, no, it isn't. Yeah, I would have opinions.
So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, The facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs.
By the way, the extreme and outrageous stuff is language from the, from the requirements. So if you're wondering why he keeps saying that, it's not to piss you off, even though it does piss you off probably. It's just to, it's just because that's the language.
And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized.
Did he say Boyle versus Wenck?
Whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 19.
Oh, I'm a child, but
79 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenged conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Kaylee as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Kaylee was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Kaylee for nearly up to 2 years. The defendant, Ms. Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Kaylee abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the
Okay, can you hear me now? Hopefully you can hear me. All right. Yes? No? Can't hear shit? Okay, we're back. Good. So could you still hear him is the important thing. So I was saying they keep bringing up Turtle Boy, but they're not suing Turtle Boy. Like, they're not suing Turtle Boy, and Turtle Boy is allowed to have opinions, and those opinions can include that, you know, the O'Keefes suck. He's allowed to think that. That is, like, within the realm of things he's allowed to think.
autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seeing before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious.
Oh, this seems weak to me. Like, they've had tragedies in the past, therefore, therefore the standard is different. No.
Campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case fits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional.
I like how they think that, like, Karen Reed seems to control Turtle Boy, because I can tell you, having seen a bit of Turtle Boy, I don't really have time to watch. Like, people are like, oh, did you watch the Turtle Boy show? And I'm like, rarely, because I don't really have time to watch people's shows. But having seen his show, having had him on the show, I can tell you, I am pretty sure you could not control Turtle Boy with like 50 people armed with like shock, cattle prods. Like, you ain't controlling Turtle Boy. And like, if I reached out to Turtle Boy and was like, hey man, you need to do this, he'd send back like, "Hey man, good to hear from you. Big fan. Go fuck yourself." Right? Yeah.
Wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases they cite. The Polite case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving.
Why say something in 5 words when you could say it in 50? Fuck.
Her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc.
Wait, has Karen Reed actually been on Turtle Boy? Because I thought that was like, I thought that was a source of drama here that she hasn't. Also, Karen Reed, if you ever want to come on the show, you are welcome. But like, yeah, I didn't think that she'd done Turtle Boy's show. So, so why is he telling the court that she's been on Turtle Boy?
There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like the it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent.
Okay. I have no idea where that went. Like, that sentence started somewhere and it went through a maze, and I was so fucking lost by the end of it.
The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to... You're over
arguing this point, and at this stage, I would rather, like, drink a glass of moths. Like, just, you got to land this plane. You got to wrap it up. So...
allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint.
Everything this man just said is bullshit.
Are allegations which we will refute.
See?
Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident, gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress.
He's like, the case is completely different.
For the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint, and again, for the record, so that people understand this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint, and the court has to consider the allegations as being
Did this guy not have more hair before this argument started? Yeah, I feel like he might have.
truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that might be asked for at some point, that this case will have a very long and tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that doesn't oftentimes bring the relief that people think it does. And so as a result, there's appellate processes. And so what I envisioned for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case. It's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that
I would like you to do this trial this spring. Somebody says, I've never heard of a pre-discovery motion to dismiss. I guess it makes sense. It's just new to me. There's often motions to dismiss before discovery because you kind of want to throw the case out before discovery if you can. So
there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk. We could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You have a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties. And there's relatively novel theories as I'm hearing it, but nonetheless, we'll let the party.
I don't know how I like that. The relatively novel. I mean, you know, I take it you haven't watched the previous trial for relatively novel theories. I mean, it is an unusual theory, certainly, but everybody knew this was coming. So, yeah.
File the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other.
The judge is like, you are not going to be happy at the end of this. Be aware that the end of this rainbow is not a pot of gold. It's a pot of sadness and dog shit floating in it. And he's like, y'all should really think about whether or not you can, like, possibly do something other than a trial. Like, literally anything other than a trial would be spectacular. And figure it the fuck out, please. Yeah. Also, this pause is a very dirty pause. So, yeah.
Avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it. And ultimately, a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going.
I think there are some content creators who are probably arranging this as like their retirement plan is to cover this trial. All right.
The clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation.
Okay, Judge, we get it. Like, you would like things to settle. Move on.
Process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process. But,
yes.
I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore it. We say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this. And I would urge the parties to have very frank discussions with their lawyers about that and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier.
The family does not give a shit how long this takes. If they live long enough and like World War III breaks out, they will be trying to litigate this on the radioactive ashes of whatever is left post-apocalypse, right? Yeah.
With a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defense,
the judge is still like, please, 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 for the love of God, settle this out. Let me free. Let me out of here. And
defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make. Ultimately, they're defendants in this case. They have to understand the risk of going forward. in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal, right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to, and we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues.
So what we're hearing here is that this is basically the judge's version of a motion to compel lunch. He's like, I want everybody to meet up. I want everybody to see each other's faces, to be friendly. And I'm like, okay, yeah.
I'd like to see, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what.
We're agnostic? Is that what you said?
Yeah, as it relates to that, we'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving.
He's like, I love his tone here. He's like, fine, we'll do it in person, which is akin to like, I will drive this courthouse right off a cliff if that's what you want to do.
Into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days out do you want to go? About 60 days, 90 days?
Yeah, probably 60 days.
60 days. November 21st, Friday in the end of November.
Yeah.
And yes, agnostic means that you are uncertain as to the belief in a God. It is kind of an odd turn of phrase here. I think maybe they meant like, ambivalent or something, but agnostic is weird as a choice here. So, yeah.
November 21st. Okay, I'll have a decision out before then, certainly, as quickly as I can. 11/21.
No, he's saying that he's going to rule on
for a
it.
status regarding tracking order and discovery, and any motions, Rule 15 motions to amend, not that, or bring in third parties. Okay, all right, thank you, folks. We'll see you then.
Thank you, Your Honor. Have a nice day.
All right, so that is the hearing for the day. A little spicy, little spicy. I don't think the plaintiffs expected all of that, but yeah. So they're going to be bringing a big application. Karen Reed's lawyers are, are going to have to prepare that, and for future things will be in hearings. So something else you guys have asked me to talk about, so we're going to talk about it, is this. This is from Turtle Boy. So, Special Prosecutor Robert Cosgrove and Robert Novak have withdrawn from the case against Turtle Boy, the one specifically respecting Lindsay Gaetani. And the reason why, so you've got Novak here's his motion to withdraw. And here is, So there's Novak. There's Cosgrove, his motion to withdraw. Now you might be saying, why would they be getting out of this one? Well, the main reason why is that Lindsay Gaetani, the victim on this one, appears to have made the decision to sue Mr. Cosgrove. And because she decided to sue Mr. Cosgrove, she then created a conflict of interest. And that was a dumb thing, right? To create the conflict of interest with the prosecutor on the case you want to see proceed. So, Gaetani just decided to blow up one of the prosecutions against Turtle Boy, and they'll have to see if they can find another lawyer to do it. But it might not be super easy to find another one, and the reason why is because, well, after you've had a whole bunch of them already do it, they may bail, like they may not be interested. Have I done anything on Kelsey Fitzsimmons? I have, yes. And we're going to do more on it as more happens, but yes. Let's go through some super chats, but first we'll start off, before we go through all the super chats, we will see some Potter eyebrows. She had a very unusual rant on some platform the other day. She did indeed. So people are asking about Potter. Potter seems, I mean, as much as Potter is like got the foot issue, he's also in really good spirits. He's sleeping a lot, which, you know, fair enough. But so yesterday, because I was sleeping, I was, you know, feeling ill, so I was having a nap. And so Potter rushed up and decided he wanted to snuggle on the bed. And so he leapt up onto the bed, rushed over to snuggle, and his cone caught me like that. And I got coned real hard. So that was fun. But once I managed to convince Potter that, like, maybe that wasn't something that needed to be done, then what do you call it? He settled down and was like just sort of leaning up against me, cone like right next to me, but just being like, I want to snuggle. So he figured out how to do the snuggles, but it took him a minute. All right, let's go through more super chats here. What is it? Brandy D, welcome aboard. Eric Parsons, welcome aboard. Glad to see you. Peyton Waysmiller, feel better, Runkle. I'm trying. We're going to go through as much of the MegaMotion as we can. We'll have to see. Mackenzie Jabali, we're so happy to have you here. Thank you so much. Sandy, thank you for 5 gifted memberships. Much appreciated. Tony P, thanks for hanging out with us. Motion for better health. I'm working on it. Part of the problem, I think, is that Mrs. Runkle does Girl Guide stuff. And that means that she goes off and she hangs out with Girl Guides who are, like, you know, full of plague. And then she comes back with plague. And then we both get plague. And so I think that's part of it. Did you hear about Officer Dever? Yeah, she gone. Dever should have known better. Like, Dever was like, oh yeah, so long as I do what they want, they're going to, you know, save my career and whatever. No. Nope. They dumped that. So, you should cover the Kelsey Fitzsimmons family court documents. Yeah, that's insane. That is insane. I see somebody saying that Melanie Little had to break the MegaMotion into 3 2-hour streams. Yeah, that's probably reasonable. We probably won't be able to get through 6 hours worth of stuff. So maybe instead of doing the MegaMotion today, maybe we'll plan to do the MegaMotion soon. What is it? Maybe we will what do you call it? Yeah. Give me 1 second here. Maybe we should do the audio here. So, all right. Let's do the leaked audio. We'll talk about that. Okay, we'll do the leaked audio and then we'll do, well, okay, maybe we'll start. So Cherry Mills, thank you so much for being a member. Michelle Curl, hey, from Puyallup, Washington. Hey, I haven't been to Washington in forever, but Pamela Wissenbach, don't get a caffeine withdrawal headache. They suck. They do, but I need to cut back on this because I was drinking like 5-6 of these a day. Sandy, let's seal the goal for Sick Runkle. Thank you so much. Joey Jones Donnelly, feel better. Caffeine counts. I'm going to try to stick to like 1 a day, and it's going to be rough, but we're going to try. David Craig, enjoy some vitamin C. Caffeine, sir. Thank you. Daniel Bossard, no, stop the Coke. Okay, here are 5. So far, I've managed to hold to just 1 today. I'm going to try to keep to that. So, yeah. Devin says caffeine withdrawal fund. Absolutely. What leaked audio? It's with regards to firearms in Canada. So, yeah. Nancy Druby, have your 1 Coke and go back to water. It's so good for you. But it tastes so bad. Dr. Vez from Quebec, enjoy some Coke, Ian. Thank you so much. Joy W. Runkle, I must have caffeine. Plus, I hope you feel better. Me too. And there's stuff I got to do. Joanna Lara, thank you so much. Phoenix, hope you feel better soon. Thank you so much. MLD, you must get sleep. I will try. Darcy Swanson says, feel better. Thank you. Peyton Waysmiller, if you get 8 hours, I will too, and I need it. Lol. I mean, I have a plan to try to get 8 hours of sleep. And, I have pledged to try to get 8 hours of sleep. So mispronounced name. Given Massachusetts thinks Bev is a good judge, I suspect this guy is thought a bad judge and got this case as punishment because he doesn't shout. I don't think he's thought a bad judge. They wouldn't give this to a bad judge. Trakushin, off to Taekwondo. We'll catch this after. I suspect that's a typo, but it's one of the most hilarious ones. How many of the pigeons did their business in the drawers at that announcement? All of them. Tranquil Moments, get well, Ian. Thank you so much. Mackenzie Jabali, thank you so much. Not that Dina, you make everything more fun, sir. Thank you again. Thank you. The World Wonders, Proctor having a rough time is just a nice bonus. Yeah, it's one of those things where it's like it couldn't happen to more deserving fellow. So I'm okay with him having a rough time. It is deserved. Tranquil Moments, will you cover the whole civil trial? I don't know for certain. So far I'm covering it, but I just I don't know. I kind of feel like Karen Reed deserves a break, and I don't know. I don't want Karen Reed trial to be the only thing I'm covering, right? I don't want it to be the only thing I'm doing. So Mildred and Katie, hope you and Puppy feel better soon. Try hot and sour soup. I like hot and sour soup. I don't have any. Purple Pixie Dust. I've been sick also, and of course shared with my husband. Sleep helps so much. Please get some sleep. I'm hoping for the best for Potter. Me too. H Scorpio, how many of them can claim qualified immunity? And Coke. We'll probably see claims. Linda Santiago, for your sleep. Sorting out the qualified immunity will be a thing. Light Queen, 8 hours. Who can sleep that long? When I'm sick, it gets easier. Cat Lady Ballerina, feel better, Runkle. Getting to sleep is harder. Especially when you are, how do I put this? When you've got chills, it really sucks trying to get to sleep. So Pamela Wissenbach contributing to the Runkle care system. Thank you so much. J. Michael MSNRN, Orange, thank you. Mary Matilda May, I hope Potter's boo-boo is not serious. Me too. Steph J, we appreciate you being here sick. Feel better soon. Thank you. I mean, Potter is such a lovely pup. He's such a sweetheart. So, yeah, I just, I hope. Have I heard about the dead thing? Yes, it's very weird. Whenever you hit a goal, I'm doing something on my to-do list. I forgot to set more goals. Everyone, please stop donating. Just kidding. Thank you. Carol Pack, thank you so much for joining up. DSN, thanks for the membership. And thank you for 5 gifted memberships. Melissa Webb, Paul Smirks in court really pissed me off today. He's got no ability to control his face at all. Carol Pack, thank you so much. Mostly Harmless Fuzzball. Every time this lawyer says JJ, I'm reminded of Donald Adelson's lawyer saying Danny. That didn't work out the way she wanted. You're not wrong. Emily Ahrens, attorney rant is giving free advertising opportunity. Yeah, I think it's mostly just that he's banging the table. Like, you know, the old adage, when you don't have anything else, you bang the table. That's what it was giving me. Megan, aka Meg, is autistic. 2 years flies so fast. I missed the 2-year freebie. Sorry about that. Daniel Bossard, we need a new goal. We do. Josh H. Turtleboy entered the chat 15 months after JJ passed. Yes. Catherine Fraser, I'd love to see the McAlberts and the Commonwealth exposed. The world doesn't always work that way. John Crump News, great job. Thank you so much. And I see the the rifle and the handgun there, so awesome. One closer to your goal. Thank you so much. Just because plaintiffs are pushing too hard, wanting cash, not justice. You're not wrong. Trakushin, is it bad that the O'Keefe lawyer is still saying Karen hit John when she's been acquitted and proven not to have not hit him? Is it defamation? Nothing that they say in court will be defamation. And also, as they point out, it's not guilty as opposed to proven innocent, if that makes sense. Gen V, that lawyer needs a better thesaurus. Yes. Iron says, just wanted to say thanks and be well. Thank you. I'm going to set a goal here. Let's do a goal because we didn't hit the vitamin C goal. Pupper pizza crusts. I have some pizza crusts. I have pups. The pups love the pizza crusts. So let's try to start that goal. Come on, YouTube. Oh, there we go. Goal is live. I'm like, why are you not goaling? So, okay, there we go. And we can turn off this banner. I put it on because that ticker was starting to annoy me. So, yeah. All right. Do I have a Brita filter? No, I just use the tap. All right, so let's dive in here. We're gonna start the MegaMotion. We will probably not finish it. I thought Zora needed to slow down in the pizza bones. I mean, you're not wrong, but we can also give her some. Mackenzie Jabali, feel better. Thank you so much. Does the defense team get to share that she was found not guilty of what is being realleged? I doubt that they'll be allowed to tender that. But they're probably going to try to sneak it in. So, yeah. All right. Let's try to bring this up. Remove, present, stop screen, present, share screen. Here we go. I missed it. What happened to Potter? Potter has a either an infection in his toe or cancer in his toe, and we don't know yet. We're waiting on the biopsy. We're hoping it's an infection, but it wasn't responding to antibiotics before, so they want to do the biopsy. Yeah, we got to find out. We're not entirely sure what's happened to him, but we're hoping that he will be okay. Anything for puppers, you got me sold. Watching from the start on 2.0. Fair enough. And Nancy Drewby says, anything for the puppers. They're good pups. When I was eating the pizza, the dogs were right there at the door. They were like, you are here. Mary Matilda May, yes, pizza bones for the puppers. Fair enough. All right. Let's hop in. So this is in the Turtle Boy case, Commonwealth of Massachusetts against Aidan Kearney. So, all right. Mark A. Bederow, an attorney admitted to practice law in the Commonwealth of Massachusetts, pro hac vice, affirms under penalty of perjury as follows. 1. I am an attorney of record for the defendant. Close PDFs. No, I don't want. Aidan Kearney. I'm familiar with the facts and circumstances herein and make this affidavit in support of Mr. Kearney's motions for A. Dismissal of the indictments pursuant to Odell and its progeny due to the prosecution's impairment of the integrity of the grand jury proceeding, or in the alternative, for the granting of an evidentiary hearing in connection with the motion. So either throw the case out or give us a hearing to get evidence on throwing the case out. So dismissal of the indictments pursuant to Bridgman and its progeny due to the Commonwealth's pervasive failure to disclose specifically requested Brady material, Giglio material, and automatic discovery under Rule 14 of the Massachusetts Rules of Criminal Procedure, or the alternative for an evidentiary hearing in connection with the motion. C. Disqualification of Special Prosecutor Kenneth Mello due to Mr. Mello being an essential defense witness at trial, or in the alternative, an evidentiary hearing on the matter. Okay. Whew. And I am just going to give my throat a spritz here because I got a bit of the sore throat action going on. So now, if you don't know Bederow is one of the smartest lawyers out there. He's also one of the funniest. He is great to see. I enjoy the heck out of him. He is pretty awesome. And yeah, that's sort of, I guess, the description there. He is one of Turtle Boy's lawyers, and yeah, he's pretty. He's kind of a shit kicker, if that makes sense. So yeah. Background: Mr. Kearney, known by the moniker Turtle Boy, is a credentialed independent journalist with large platforms on social media and YouTube. He writes articles and regularly hosts live YouTube shows, which are generally 2 to 3 hours in length and address numerous topics of public concern. Mr. Kearney's YouTube videos are categorized sequentially as numerical episodes, each of which contains a unique title summarizing the contents of his shows. Episode numbers and titles of Mr. Kearney's shows are displayed prominently on his YouTube page and may be viewed by anyone, irrespective of whether they subscribe to his channel, i.e. they're open to the public. So, Mr. Kearney's investigative reporting has exposed numerous examples of fraud, corruption, and wrongdoing. He often intersperses his journalism with elements of comedy, satire, and activism. Not surprisingly, many people who become the subject of his reporting and content don't like him. So, yeah. I feel there's a lot of people who really dislike, Turtle Boy because Turtle Boy has kind of shined a light on them. And yeah. In April 2023, Mr. Kearney began researching the Karen Reed case, which at the time appeared to be a straightforward open and shut vehicular homicide case. After he reviewed publicly filed court documents and acquired information from sources he generated, Mr. Kearney quickly realized that the case against Ms. Reed was far more nuanced than had been publicly reported up to that point. Since he first delved into the circumstances surrounding how John O'Keefe, a Boston police officer, ended up dead on the front lawn of fellow Boston police officer Brian Albert shortly after Ms. Reed dropped him off at Mr. Albert's Canton home in her Lexus SUV, Mr. Kearney's reporting and content creation has centered on his unabashed belief that the Norfolk County DA's office, the DA, and the Massachusetts State Police, MSP, framed Ms. Reed with assistance from Jennifer McCabe, members of the Albert family, and others who participated in Mr. O'Keefe's death and/or helped cover it up. On April 18th, Mr. Kearney published his first article about the Reed case, Canton Cover-Up Part 1, Corrupt State Trooper Helps Boston Cop Cover Up Murder of Fellow Officer, Frame Innocent Girlfriend. Mr. Kearney's initial Canton Cover-Up report was primarily sourced from by the April 12, 2023 90-plus page court filing from Ms. Reed's defense, which consisted of an affidavit from her attorney supported by numerous exhibits, including police reports and data from an extraction report of Ms. McCabe's cell phone. Mr. Carney reported that Brian Albert, Ms. McCabe, Matthew McCabe, Chris Albert, Colin Albert, and Julie Nagel were definitely in the house at the time Mr. O'Keefe was killed, and that all of them witnessed the murder or are aware of it and have said nothing. Most of them were not questioned by now terminated and disgraced Trooper Michael Proctor. Mr. Carney's article highlighted the Reed defense's claim that Ms. McCabe Googled "Hoss Long to Die in the Cold" at 2:27 a.m. on January 29, 2022, which, if true, was damning evidence of her complicity in and/or knowledge of the circumstances surrounding Mr. O'Keefe's death, because there is no way for her to have known that anybody was dying in the cold to wonder Hoss Long about unless she knew, right? And the only way she could have known is if she was involved, or at least knew about it. So most of the individuals criticized in Mr. Carney's April 18th article for the alleged involvement in Mr. O'Keefe's death or its cover-up later became the allegedly intimidated victims in the indictments against Mr. Carney. Indictments related to Mr. Carney's purported intimidation of Mr. Proctor and Sergeant Yuri Buchanan were later dismissed by the court. Also, if you are a police officer and you are intimidated by Turtle Boy, y'all need to fucking retire and not be a police officer anymore. Because, not to throw shade at Turtle Boy, but he's not a big menacing dude. And I don't think Turtle Boy owns any guns. I don't see that Turtle Boy. Now, Turtle Boy might embarrass you. He might, he might expose you, but he's not going to show up and murder you or anything like that. So, if Turtle Boy was pissed at me, I'd be like, oh shit, maybe he's going to write a nasty story about me. But I would not be thinking, oh shit, Turtle Boy's going to take me out. So, yeah. Mr. Carney's well-sourced, dogged reporting and outspoken support of Ms. Reed's innocence lit the spark that quickly ignited the Free Karen Reed movement, a phenomenon which galvanized worldwide support for Ms. Reed and relentless, blistering criticism of the DA, MSP, and the civilians whom Mr. Carney and many others believe concealed the truth about Mr. O'Keefe's death. Mr. Carney's coverage of the Reed case, which to date includes 528 Canton cover-up articles and hundreds of video episodes, virtually overnight transformed a mundane Massachusetts criminal case into perhaps the most high-profile and scandalous murder prosecution in the United States in decades. And that link goes to a Fox News article. Juror reveals why Karen Reed walked free. Mr. Carney's frequent reporting on the Reed case has played a substantial role in the public's loss of confidence, which goes to DA refusing to answer questions following Karen Reed retrial, in the integrity and competence of Norfolk County law enforcement, an ongoing scandal that continues to plague the DA and MSP in the aftermath of Ms. Reed's acquittal. But for Mr. Carney's reporting, disgraced former Trooper Proctor would still be investigating serious cases for the MSP. Other members of the MSP, including Detective Lieutenant Brian Tully, the lead investigator against Mr. Carney, and Sergeant Buchanan, wouldn't have been publicly disciplined for their misconduct, and the Norfolk DA's State Police Detective Unit wouldn't have been dismantled due to their misconduct in the Reed case. Mr. Carney's exposure of the DA's and MSP's misconduct in the Reed case has complicated the murder cases against Brian Walsh and Miles King. It has led to significant criticism of the DA's investigation into the death of Sandra Birchmore, which it classified as a tragic suicide, but which many believe was a whitewash. In 2024, the U.S. Attorney's Office thoroughly rejected the DA's findings and indicted former police officer Matthew Farwell for Ms. Birchmore's murder. So, although Mr. Carney's reporting on the Reed case raised significant or disturbing questions about the possibility of systemic corruption in Norfolk County and gained him tens of thousands of supporters. The public officials and private citizens he is accused of wrongdoing, and the microscopic segment of the population who remain convinced of Ms. Reed's guilt, despite her acquittal, despise him for his coverage and opinions. Since Mr. Carney exposed the scandal surrounding the Reed case on April 18th, Ms. McCabe and the Alberts have repeatedly used the criminal justice system as the instrument to silence Turtle Boy and end the persistent criticism his reporting has caused and still causes them today. Summary of the motions. All right. So we are on page 8 of 88. We'll see how far we make it before I crap out. Oh, and apparently there are some PayPals to hit the goal. So, all right. I am told that the PayPal, or with PayPal, the goal's been met. So, let's see if I can call some doggos. I'm just going to pull those out. Pizza crusts. 1 second. All right. So for some reason, my mic keeps dropping out, and I don't know what the reason is, and I don't know how to fix it. I'm going to try to figure that out, but I didn't mean to mute. I didn't mean to mute, so my bad. What is it? I was just saying that the puppies are very cute, and yeah. I don't know why the mic keeps dropping out. It is a thing. So he muted it because the dogs were talking smack about us. All right. Carrying on here. So summary of the motions. The primary evidence used to secure Mr. Carney's indictments were shortened, edited, and renamed segments from his hours-long YouTube episodes, which had the effect of skewing the true context of Mr. Carney's episodes. Oh, geez. Okay. So we got a spammer, and the spammer is gone. Yeah, we're not doing that. Spammer, goodbye. So, yeah. All right. For months prior to the grand jury proceeding, D.L. Tully and Mr. Mello were familiar with Mr. Carney's actual episodes, including their true names, length, and context. Oh, Jesus. And there's another one. And there it goes. Let's see. Let me just let's see, customization. We're just gonna fix this. All right, so hopefully that should we're on subs only, so that'll limit them. Where is Fightbot? I'm not sure. So yeah. All right. So, during the 2 months prior to the grand jury proceeding, D.L. Tully and Mr. Mello welcomed unvetted evidence and guidance from Catherine Peter, a private citizen who they knew harbored an unhealthy obsession and hatred for Mr. Carney. Ms. Peters' dreadful credibility included incidents in 2020 and 2023 where she falsified and forged evidence to harm Mr. Carney. Ooh, that's an interesting link. Kate Peter drafted a false or fraudulent federal complaint. That's on TB Daily News against me for copyright in order to get a YouTube video removed, but used an already existent docket number. Whoops. So the latter of which included her audacious defamation and exploitation of Colin Albert and Chris Albert to further her insatiable urge to embarrass Mr. Carney. Ms. Peter provided D.L. Tully and Mr. Mello with video and audio evidence, including edits from Mr. Carney's lengthy episodes, which she believed evinced Mr. Carney's intent to intimidate witnesses. As detailed in the accompanying affidavit of Courtney Healy, ooh, that'll be fun. We'll have to look at that. According to D.L. Tully, Ms. Peter directed him to specific timestamps of Mr. Carney's episodes, which he located and edited, rather than review the linked files provided to him by Ms. Peter. D.L. Tully apparently renamed the edits he made for Mr. Carney's episodes such that they didn't accurately reflect the names created by Mr. Carney, and saved them in folders he created, which included at least one he named Intent. The problem with renaming them is that if that ends up going to the grand jury, then the grand jury is going to see that they have these names, and the names are not going to be correct. So, yeah. So, the edited and renamed files in the intent folders D.L. Tully created were the exact files that became the exhibits that Mr. Mello introduced and D.L. Tully described before the grand jury. Mr. Mello's direction to the grand jury proceeding made a mockery of Mr. Carney's right to due process, the cumulative impact of which impaired the integrity of the grand jury and grand jury proceeding and prejudiced Mr. Carney. So, Mr. Mello littered the grand jury proceeding with his improper comments, his unsworn opinions of the evidence, and Mr. Carney's intent, and by twice eliciting D.L. Tully's opinion that Mr. Carney intended to intimidate witnesses. You can't bring like intention in there like that. And let me just adjust the audio. Okay, there we go. Interac e-transfers are also an option, but depending on which address you send them to, they may need to be, they may need to be sort of processed. So, Mr. Mello provided the grand jury with improper legal instructions and failed to give appropriate limiting instructions. He improperly alerted the grand jury about the possible sentences associated with the crimes for which he sought indictments, and even a charge for which he did not seek an indictment. Mr. Mello dedicated the first day of the grand jury proceeding to dirtying up Mr. Carney through his introduction of irrelevant and prejudicial information related to an uncharged allegation of Mr. Carney wiretapping Stephen Scanlon, a topic entirely unrelated to the witness intimidation allegations before the grand jury. Wait, what's this allegation? I don't think they've actually brought a charge for that, because that would be a thing. Mr. Mello and D.L. Tully misled the grand jury by limiting evidence of Mr. Carney's intent to D.L. Tully's edits of his episodes, which left the grand jury with inaccurate and far more incriminating information about the names, length, and context of Mr. Carney's episodes, rather than affording the grand jury access to his authentic episodes, which would have provided it with the authentic and favorable context of Mr. Carney's statements. I would want them to play the entire thing. right? At least 28 times during the course of the grand jury proceeding, Mr. Mello elicited from Detective Tully materially false and misleading testimony about Mr. Carney's YouTube episodes, which gave the grand jury the false impression that he created the episodes to document his alleged intimidation of witnesses, which would be weird. And I see somebody saying make a new goal. I'm not going to make a new goal because I'm going to wrap things up fairly quickly. And so we're not doing a new goal because Despite numerous defense demands for specific evidence from September 24th to August 2025, the DA has failed to disclose exculpatory or discoverable evidence, or at a minimum, explained what efforts, if any, it made to locate the requested evidence. The defense made a prior defense motion to dismiss the indictments without access to important undisclosed evidence that was in the Commonwealth's possession, custody, and control prior to the filing of the motion. Communications between Ms. Peter, Mr. Mello, and D.L. Tully, which are relevant to the instant motion to dismiss the indictment, have been in the Commonwealth's possession, custody, and control since 2023. Obviously, they would, right? Obviously, they would have those things because anything that Mello and Tully have, they have. And were the subject of specific demands on September 12th and October 8th and October 17th, but were not disclosed to the defense until months after the court decided our initial motion to dismiss. Mr. Mello forwarded many of the communications relevant to the instant motion to dismiss the indictment to co-counsel Robert Cosgrove on December 16th, but Mr. Cosgrove didn't provide them to the defense until July 7th, notwithstanding specific defense demands for that exact evidence addressed to both months before the defense filed the first motion to dismiss the indictment. This is looking really bad, right? This is looking really, really bad. Yeah, I'm not going to click every link here because most of these links you see are just to like news stories and so forth. But we're going to get to a good break point and then we're going to break. The communications between and among, my throat is starting to give out and that's not going to be good. So also I looked at the screen and I was like, why is the screen blurry? What am I doing wrong? Do I have a bad configuration? And then I was like, screen fine, eyes tired. So yeah, the communications between and among Ms. Peter, Mr. Mello, and D.L. Tully, recently disclosed by the Commonwealth, established that the defense still hasn't been provided with A, private video links that Ms. Peter sent directly to Mr. Mello and D.L. Tully, B, photographs and other evidence Ms. Peter sent Sergeant Buchanan, and C, communications between Ms. Peter and D.L. Tully regarding the assistance she provided D.L. Tully immediately before he accessed Mr. Carney's actual episodes and edited them, changed their names, and placed them in an intent folder he created for use in the grand jury. The DA now claims that numerous private links containing discoverable information about Mr. Carney that Ms. Peter provided to Mr. Mello and D.L. Tully have since been deleted by a private party, i.e. Ms. Peter, who they have shut down all of the stuff. The Commonwealth has represented that D.L. Tully has never opened any unsolicited links emailed to him by Ms. Peter. Notably, they have not and cannot say the same about Mr. Mello, who not only opened private links sent to him by Ms. Peter, but also sent them to D.L. Tully for him to review. It's like, I didn't open the private links. This other guy did and sends the content. Yeah, I've seen some people commenting to basically like throwing shit over Bederow's font selection and size. This is a good font. Like, there's nothing wrong with this font. So, yeah. Whoop, I just saw this one. Just me says, longtime listener, first super chat. Why, if a defendant is presumed innocent unless and until proven guilty, are not presumed innocent if not guilty? Makes no sense. This senior citizen from Augusta, Kansas. She is still presumed innocent, but it's not the same as being proven innocent, if that makes sense. So where's a good break point? Do we have a good break point? We have a good break point here. We're going to go to the good break point, and then we're going to we're going to stop at that point. We're stopping on page 15. Okay. Therefore, favorable and discoverable and evidence that was indisputably was in the Commonwealth's actual possession since 2023. Is it me, or does that sentence have some grammar problems? Yes, it has grammar problems. I'm not just that tired. Okay. Apparently, is no longer available for disclosure to the defense. This is a critical thing. The reason why this is critical is with respect to remedies. Because let's imagine that my client is accused of a murder, right? And then it turns out that there's a person who witnessed the actual murder, right? And they witnessed the actual murder and they, they saw everything. But the prosecution doesn't tell me, what actually went down. And so, but they tell me like 6 months later, right? Now, the court, when deciding what to do about that, failure to disclose this witness for 6 months, is going to have a much different response if it's just, well, okay, defense counsel, now you can go talk to the witness, and the witness is totally alive, and you can, and you can totally see that, and we're going to ban another person. Yeah. That's going to be one thing. But if the witness has since died, right, and the witness is no longer available, I can't go talk to them, then the court will probably be extremely upset about this. And I see the person who did the hyperlinks, Olivia Nile, is in chat. Oh, hey. And then I saw, hi. Good to see you, Olivia. So, yeah. Somebody says, who is he banning? There's somebody who keeps coming in and spamming a bunch of stuff about, the conflict in the Middle East. And it's not what this stream is about. And also anything you want to make as a point is best made as a, you make an argument. You don't just spam it out, because spamming it out just doesn't do anything. All right, let me see if I can get Nightbot online as well. Nightbot. All right. Chat moderation. Where? Dashboard. Nightbot. Leave channel. Join channel. Do we have Nightbot online? All right. There we go. So I'm trying to configure Nightbot. We are going to add to chat a blacklisted. So we're going to do that. We're going to add to repetitions. Ooh. All right, so that's there. We're also just going to add to the blacklist. And let's see. There we go. There we go. Hopefully that'll fix things. Fightbot is on. All right. Let's see here. Let's just add another word here. That one's an obnoxious word, but it'll come up all the time. But so there we go. We've got Fightbot further reconfigured, I hope. We'll see if Fightbot actually gets to actually does something. I don't know if Fightbot is actually functional here. All right. Mr. Carney has been prejudiced by the non-disclosure and / or destruction of exculpatory and discoverable evidence because the defense has been deprived of critical, substantive, and impeachment evidence in support of the claim that the DA's biased and shoddy investigation relied upon unvetted and possibly tampered evidence from a source with a patently obvious motive to falsely accuse Mr. Carney and with a track record of doctoring evidence against him on at least 2 occasions. And yes, I did add a very common word to it. Oh, and it looks like our spammer is trying very hard and is running up against Muffin. I am so sorry that Mr. Spammer dude is not having a good luck. All right. Let's see. Yeah, don't fight. Let's just do that. It's going to be a battle today, I suspect. But you know what? This part is kind of fun. This part's kind of fun. The spammer fight is entertaining, and I guess is giving me a bit more energy here. So, yeah. All right. Mr. Mello's communications with D.L. Tully and Ms. Peter regarding a relationship with and production of evidence to the prosecution, the likelihood that he will contradict D.L. Tully's claim that he's never reviewed private links sent by Ms. Peter, his knowledge of Ms. Peter's motive to falsely accuse Mr. Carney, and her overall lack of credibility, his knowledge that D.L. Tully edited and renamed evidence that he later introduced to the grand jury, and his conduct before the grand jury, which included eliciting false and misleading testimony from D.L. Tully, supports Mr. Carney's defense and will make Mr. Mello an essential defense witness at trial. The prosecutor doesn't want to be a witness. Yeah, you know what? We're just going to adjust the subscriber time just a wee bit. We're not going to keep it that long, but we are just going to adjust it just to make a spammer unhappy. Minute. There we go. All right, so our spammer's got at least an hour to wait on his Okay, once again it dropped out. Video down now too, you liar. Hopefully you guys can hear me. Yes. All right, good. I don't know what I gotta fix here for this to work, but yeah. Mr. Mello made himself a material witness when, in his official capacity as Mr. Carney's prosecutor, he called the police advocating on behalf of, witness Chris Albert by seeking to have peaceful protesters assembled across the street from Mr. Albert's pizza shop, charged with witness intimidation. So, yeah. And speaking of subscriber only chat, I've seen those hijacked accounts run live streams with 50 years subscription requirements to effectively ban everyone except the hacker's own accounts to appear legit. Oh, lovely. All right. Mr. Mello's conduct and credibility will be key issues at trial, and it would therefore be improper for him to represent the Commonwealth and defend himself as an unsworn witness. Mr. Mello must be disqualified pursuant to Rule 3.1 or 3.7, which mandates that a lawyer shall not act as an advocate at a trial in which the lawyer is likely to be a necessary witness. This court has disqualified Mr. Mello for prosecuting Mr. Carney in docket, another one for the exact same reasons being sought here. This is also a solid thing here because if he's been disqualified on one matter, then he's more likely to be disqualified on another. Accordingly, for the reasons detailed in this affidavit, its exhibits, and the accompanying memorandum of law, the court should dismiss the indictments against Mr. Carney and disqualify Mr. Mello, or in the alternative, order an evidentiary hearing on the motions because the prosecution has prejudiced Mr. Carney by A, intentionally impairing the integrity of the grand jury proceeding, and B, failing to disclose specifically requested exculpatory and discoverable evidence in their possession, custody, and control, and Mr. Mello's conduct has made him an essential defense witness. Whew, okay, that takes us to a good break at the need to silence Mr. Carney. We will pick up where we can. We're going to go through the super chats. Deborah G, all the best to Potter. Thank you so much. Hello, it's Britt. Just went through this exact same thing with my cat in his mouth. And they went to do the biopsy, and it was gone. Wish the same luck to you. They did the biopsy, and they saw the thing. So, yeah. Sandy says, for the pizza bones, please don't stream too long. We need you well. I'm going to wrap it up pretty shortly. And, we won't give that spammer time to come back. Big Dog 5758, need those puppers to get the pizza bones. I have one crust left, and I will probably share it between the two. Or maybe I'll just give it to Potter, because Zora's gotten a little chunkified. Wolf Lore Lover, thank you so much. Big Dog 5758, Pizza Crust or Barkapalooza 2025 begins. So thank you. Goal, thank you. Mackenzie Jabali, I feel for Potter the Conehead. Yeah, he's having a rough time. Equality. Hi, Ian. May I be selfish again and ask for good luck on my tax exam on Wednesday? Good luck. You're going to kill it. You guys helped a lot last exam. I love your community. Thank you so much, Equality. Love having you here as well. Oliver Closeoff says, side topic, but thanks for covering the gun confiscation program in Canada. Sadly, I don't see this or self-defense changing anytime soon in Canada. I would love to see it change, but the real Jim McIntyre, I don't know why anybody would be intimidated by Turtle Boy. It's not like his last name is McCabe. Fellow survivor of the pup cone bash attack here. Get well soon, pup. The thing I'm worried about with the pup, with the cone, is that I'll be standing at the top of the stairs and he'll come and bump up against my legs with the cone. And I'm worried he's gonna fire me down the stairs. So I have some concerns that he might launch me down the stairs one of these times. And he's like, serves you right for having this damn cone. Yeah, I just we'll see. Handrails. I don't have handrails. All right. No, the inflatable cone doesn't work. The reason why is because it's not about him turning his head to get at his back. It's about him getting in his paw. So if the cone doesn't block him, he reaches up around the cone and then gets it to his mouth. He gets his paw to his mouth. It's he's kind of a troublesome pup like that. And I see somebody saying, don't stand at the top of the stairs. If you're going, go. If not, back away. Sometimes Mrs. Runkle is downstairs, and I will talk to her from the top of the stairs and be like, hey, what's going on? So, yeah. All right, let's wrap this up before I collapse because I'm getting there. It's good to see all you folks. We need to do like a celebration stream. I don't know. I keep feeling like I got to move off of the Mondays because Mondays are kind of not a great day. But I don't know if it's the Mondays or if it's just me. But yeah, it's I don't know. It's been kind of quiet. So we'll see what's going on. Anyway, talk to you guys soon, and we'll go from there. And I gotta turn Fightbot back down. Do you ever do unpopular legal opinion streams? I feel like I have. So, yes. All right. Good night, all.